The year was 1972. In a village named Desaiganj, a girl named Mathura lived. Her parents died when she was a child, and she lived with her brother Gama. To earn a living, both worked as laborers. Mathura worked as a domestic help. She met Ashok and wanted to marry him, but her brother did not approve of this relationship. Since her brother did not approve of the relationship, Mathura eloped with Ashok, which made her brother Gama to go to the local police station and lodge a complaint on 26 March 1972, alleging that Mathura, a minor, was kidnapped by Ashok and his family. The report was recorded by Head Constable Babu Rao. Following general investigation, Mathura, her brother, Ashok and his family members were permitted to go back home. But something extremely weird happened. Mathura was asked to stay behind, while her relatives were asked to wait outside. She was then taken inside, behind the building, and was raped by Ganpat and Tukaram, the duty constables. She couldn't resist, she couldn't shout, but she came out crying and told everyone about what happened to her. The crowd was furious and threatened to burn down the police station. The constables got scared and agreed to file an FIR against themselves. The case came on hearing on 1st June 1974 in the Sessions Court. The trial court held that Mathura was habituated to sexual intercourse. Girls like her often surrender themselves to people with authority for benefits and help. Mathura did the same. What those two constables did it with her consent, and the court said that it was not rape. Like this wasn't enough, the court also observed that there is no injury on her body. Her clothes weren't tattered, she didn't shout for help, she didn't even resist. If she resisted, there would have been marks. How is it rape? The act was voluntary, and the Sessions Court acquitted those two rapists. A girl who was raped at 15 years of age was brutally denied justice. But Mathura didn't give up. She challenged the judgment in the Nagpur bench of Bombay High Court. The High Court observed that there is a difference between consent and passive submission. A tribal girl of that age cannot be expected to resist against two middle-aged, well-built constables. She's a 15-year-old child. Even if she cried for help, that cry could have been easily curbed. She didn't resist because she couldn't. She was scared, terrified, traumatized, and that is not consent. The court held that passive submission due to fear induced by serious threats could not be considered as consent or a willing sexual intercourse. But the story was far from over. The High Court judgment was challenged in the Supreme Court, and what happened thereafter shocked the entire nation. In September 1979, the Supreme Court of India, in their judgment on Tukaram versus State of Maharashtra, reversed the High Court judgment. The Supreme Court held that Mathura had raised no alarm and there were no visible marks of injury on her body, thereby suggesting no struggle and therefore no rape. The judge noted because she was used to sex, she might have incited the cops, since they were drunk on duty, to have intercourse with her. A 15-year-old child incited the cops to rape her, and it wasn't even rape. The appellants were acquitted, stating that this alleged intercourse was a peaceful affair. In 1979, only a few days after the verdict was pronounced, law professors Upender Bakshi, Raghunath Kelkar, and Lotika Sarkar of Delhi University and Vasudha Dhagamvar of Pune wrote an open letter to the Supreme Court protesting the concept of consent that they had interpreted in the judgment. The guardians of our constitution, the protector of our fundamental rights, were asked if they really believed that a poor, hungry, scared 15-year-old could shout, stop, or even resist against two men from doing anything that they wanted. People who belong to an underprivileged section are exploited, demeaned, treated like vermin, and they tolerate everything with their heads bowed, not because they want it, they consent to it, because they don't have the courage to stop it. This is exactly what happened to that child. She submitted because she was terrified, and that is not consent. There was a public outcry and protests by women's organizations who demanded a review of the judgment. And this received an extensive media coverage. But did our apex authority of justice delivery budge even an inch? No, they didn't. The courts ruled that there was no locus standi in the case to rule in favor of Mathura. There was no justice for Mathura. But that case, a rape of a 15-year-old, changed the history. Eventually, Government of India amended the rape laws, and thus came the Criminal Law Second Amendment Act of 1983. This Amendment Act made a statutory provision in the face of Section 114A of the Evidence Act, which states that if the victim says that she did not consent to the sexual intercourse, the court shall presume that she did not consent. Meaning thereby, अगर एक लड़की कह देती है कि उस सेक्सुअल एक्टिविटी में उसकी मर्जी नहीं थी, उसकी हाँ नहीं थी, तो कोर्ट ये मान लेगा कि उसकी मर्जी नहीं थी. Besides defining custodial rape, which this amendment did, it also shifted the burden of proof from the prosecution to the accused once an intercourse was established. It also added provisions for in-camera trials, the prohibition on the victim identity disclosure, and tougher sentences. Section 376, which prescribes a punishment for rape under the Indian Penal Code, underwent a change with enactment and addition of sections like 376A, 376B, Section 376C, and 376D of IPC, which made custodial rape punishable, which was further amended in 2013 after Nirbhaya rape case. Years later, Mathura was interviewed by a reporter from CNN. The reporter at the end asked her, "Are you happy, Mathura?" She replied, "Happiness, sadness, how does it matter? What matters is I survived. But I had to survive without justice."